How does the burden of proof work in will challenges? Imagine trying to convince a judge that a will is invalid. It might seem straightforward, but the rules about who needs to prove what can be quite specific. When someone challenges a will, the person making the challenge, called the contestant, usually has the burden of proof. That means they need to bring enough evidence to convince the court that the will should not stand. In most cases, the person who made the will, known as the proponent or executor, first has to show that the will was properly signed and followed all legal rules. This includes showing that the will was signed voluntarily, with the testator having the mental capacity to understand what they were doing, and that it was witnessed correctly. Once the court is satisfied that the will was properly executed, the burden shifts to the person challenging it. The challenger then needs to prove that the will is invalid for reasons like the testator not having enough mental capacity, being under undue influence, or being tricked into signing it. The standard of proof most often used is called preponderance of the evidence. This means the challenger must show that it is more likely than not that their claim is true. In other words, they need to tip the scales just slightly in their favor. Sometimes the law presumes certain facts. For example, if someone benefits from the will and is also the person who drafted it or was in a position of trust, the court might assume undue influence. In that case, the burden shifts to the beneficiary to prove they did not influence the testator improperly. In some situations, a higher standard called clear and convincing evidence is required. This is a stricter level of proof, meaning the challenger must provide evidence that leaves little doubt about the invalidity. To meet these standards, challengers often gather witness statements, medical records, or documents showing signs of incapacity or undue influence. The person defending the will try to show that the testator was of sound mind, acted freely, and followed all legal steps when signing. Understanding who bears the burden of proof and what standard they must meet is key in will disputes. It can determine whether a will is upheld or set aside. Because these cases are often about subtle details and personal testimony, knowing the rules helps both sides prepare their strongest case. Acting quickly is also important, as there are time limits to file a challenge once the will is admitted to probate.